Thank you for joining us for the third session of our Workplace Wednesdays webinar, focusing at this point on traditional labor law. I'm Kelley Stoppels. I'm a member in the Labor and Employment section at Miller Johnson. I'm joined by my partner in crime, Jeff Fraser, who's a fellow member here at Miller Johnson, and our guest speaker and friend, Bruce Lillie, who is one of our business associates. Combined, we have 80 plus years of labor experience at your disposal this morning. So we are excited to spend some time talking with you about some changes potentially on the horizon under the Biden administration. Legal disclaimer, listening to or participating in the webinar doesn't create an attorney-client relationship. Really, the information this morning is for your edification and informational purposes only. So as we've mentioned, this is a multi-part series focusing on traditional labor law and specifically focusing on the PRO Act. Next week, please join us back here. Nate Flanagan and I are going to be talking about, oh no, you lost an election under the proposed rules. What happens next? And then following that, on St. Patrick's Day, we're going to have Keith Eastland and Patrick Edsinga doing a deeper dive, as if you haven't gotten enough already, into the PRO Act employer penalties. So please join us for those upcoming webinars. So today's focus. Today we are going to be talking more about the PRO Act. That's the Protecting the Right to Organize Act of 2021. We're going to be spending a little time reminding you about the background of the Act, what the purpose is, what the goal is of the Act. We're going to give you some practical advice, and then we're going to be marching through some of the changes that will impact union organizing under the PRO Act as currently drafted. We think the best way to really give you a good reminder of where we are in the United States related to union organizing is to play a short video clip for you. It's a video, a 2-minute video that President Biden actually issued earlier this week, encouraging union organizing. He doesn't directly mention the union organizing that I'm sure you're all aware of that's going on right now with Amazon down in Alabama. But President Biden does talk about workers in Alabama and uses some very strong language to encourage unionization. So with that, we'd like to go ahead and play you this video.
I've long said America wasn't built by Wall Street. It was built by the middle class, and unions built the middle class. Unions put power in the hands of workers. They level the playing field. They give you a stronger voice for your health, your safety, higher wages, protections from racial discrimination and sexual harassment. Unions lift up workers, both union and non-union, and especially black and brown workers. I've made it clear when I was running that my administration's policy would be to support unions organizing and the right to collectively bargain. I'm keeping that promise. You should all remember, the National Labor Relations Act didn't just say that unions are allowed to exist. It said that we should encourage unions. So let me be really clear. It's not up to me to decide whether anyone should join a union. But let me be even more clear. It's not up to an employer to decide that either. The choice to join a union is up to the workers, full stop, full stop. Today and over the next few days and weeks, workers in Alabama and all across America are voting on whether to organize a union in their workplace. This is vitally important, a vitally important choice as America grapples with the deadly pandemic, the economic crisis, and the reckoning on race. What it reveals the deep disparities that still exist in our country. And there should be no intimidation, no coercion, no threats, no anti-union propaganda. No supervisors should confront employees about their union preferences. You know, every worker should have a free and fair choice to join a union. The law guarantees that choice. And it's your right, not that of an employer. It's your right. No employer can take that right away. So make your voice heard. God bless you all, and may God protect the workers and their families who are trying to figure out how to make it fairly. Thank you.
So as we just heard from President Biden, right there, a couple things are evident, right? He clearly is doubling down, making good on the statements that he made throughout his campaign to be the most pro-labor president ever. In my experience as an attorney, this is really unprecedented to see that kind of strong statement video from a sitting president supporting unionization and really calling out an event that's happening presently at a large company here in the United States. The other thing that that video does is I think it really highlights the changes and the background of why the PRO Act stands a very good chance of moving forward. Background on the PRO Act: it was introduced in the fall of 2019. It passed the House of Representatives in February of 2020. And, you know, honestly, my view of it is it really didn't get a lot of press. People weren't paying a ton of attention because it moved over into the Senate and kind of stalled out in committee. Well, fast forward, we have a new election. Any number of events occurred in 2020, and now we're in a very different situation. As President Biden said in his video address, he really hits on the fact that there are a lot of forces at work over the last year. We've obviously been dealing with COVID. People are very concerned about their health and safety in the workplace. Biden hit on that. We also have had amazing social and cultural changes with renewed focus on systemic racism and barriers to inclusion, and that includes the workforce as well. And President Biden hit on that during his address as well. And all of those forces at work, combined with the Democratic administration, have created a situation that really is ripe for development in the area of traditional labor. So I'm sure some of you on the call, as you're thinking about the PRO Act, you're remembering back to 2009 and the Employee Free Choice Act, EFCA, and kind of thinking, well, you know, why are we getting so wound up about this proposed legislation? You know, I saw this 12 years ago and EFCA ended up stalling out. It ended up being no big deal. Why is this different? Why should I pay attention now? Well, what I just highlighted is why this is different. It is a very different cultural background. We have a very, very activist president, and we have a situation where in Congress, there's a split. So in the Senate, depending on whether or not they retain filibuster and what we see happening there could be some real action and traction in moving the PRO Act forward. We'll see what happens. Again, I think it is going to depend on what happens in the Senate, but I think it is certainly possible that the PRO Act gets passed in whole or pieces passed tagged to other legislation. Either way, this is something that every employer needs to be paying attention to. So what does the PRO Act do? As we here at Miller Johnson take a look at this act, this is what we see. You know, make no mistake, it is going to tip the scales in favor of employees and unions. And I think that there is this inclination on the part of non-union employers to kind of tune out when it comes to traditional labor law, union issues, the National Labor Relations Act. Well, that just applies to union settings. This doesn't apply to me. No, this act is going to impact everyone, union and non-union employers. So everyone should be paying attention to this. Our view is that the PRO Act really does three main things, right? First off, it expands union and employee rights related to organizing and bargaining. The second thing it does is simultaneously restricting your rights as the employer to speak to your employees, to oppose unionization. There are also restrictions on bargaining if you end up losing a campaign. And then third, really silencing the employer's voice. There is expanded scope of action that violates the law. You're excluded from many election procedures, and there are increased penalties and remedial provisions. So on a broad kind of 3,000-foot view, this is what the PRO Act does. And we're going to get into it in a little bit more detail, but this is what we see overall. So the PRO Act purpose. The language, it's interesting, the title of the act, Protecting the Right to Organize Act, it seems very innocuous. It seems very benign, right? If you just look at that title, you know, who wouldn't be in favor of protecting individual freedoms? Of course, we know that people have a right to organize their workforce if they think that a union would be beneficial to themselves or their colleagues. We need to be clear, though, that the PRO Act, it's not just about protecting employees' rights to organize in the workforce. I think that the proper name for the PRO Act would be PRO Act on steroids, organizing on steroids, or maybe the Silencing Employers Act. Make no mistake, the goal of this act is to make it much easier for unions to organize your workforce and to transfer wealth, power, authority from corporations and corporations' officers to employees through collective bargaining. And despite the title of the act, if you take a look at the communications around the PRO Act, it is very, very clear from the highest authority in the land, from President Biden, all the way through union leadership, that that's the goal. The goal is to make it easier for unions to organize and encourage union organizing and penalize companies that get in the way. Union leadership has also made it very, very clear that this is the payout they expect with the shift to Democrats in the White House. The expectation is that this will be passed and signed into law. I've included a quote here from the AFL-CIO president, and to be honest, if you spend 2 seconds Googling the PRO Act online, you can find 100+ quotes from organized labor talking about the PRO Act, how great it is for workers, how important it is that it is passed, and the expectation that it's passed. And I think if you look at this quote, what really jumps out at me is that fourth line. Make no mistake, this is a test for Democrats. After decades of disappointment, it is time for the party of FDR to finish what he started. Clearly, call to arms there, right, by the unionized workforce. This is what the union expects. They expect the PRO Act to pass. There is enormous pressure on the Democratic Party to deliver. And a couple quotes from President Biden. So the quote on the left is a tweet that candidate Biden sent out when he was running his campaign. And again, he is specifically talking to the labor unions. He's letting them know, hey, yeah, I'm going to sign the PRO Act. I'm going to make it easier for employees to organize and bargain. I'm going to be the strongest labor president workers have ever had. And then on the right, we see a tweet from President Biden. And again, he's doubling down on that and saying, hey, our policy is to encourage union organizing. And that's what this is about. The PRO Act is a wish list for unions. It's what they want, it's what they're saying they need, and it's going to help them organize your workforce. All right, so we've talked kind of on a high level about the background and why we and why you should be taking this very, very seriously. Let's talk a little bit about changes impacting union organizing under the PRO Act. We're going to hit on some of the key provisions and let you know why you should be keeping an eye on it. So card check organizing. I'm sure you're all familiar with union authorization cards. Union authorization cards are the cards that unions, when they are organizing your workplace, they have employees sign off on those cards. We've been seeing more of that happening electronically, or it can also be kind of the old school paper cards, basically stating, yes, I want this union to represent me for purposes of collective bargaining. The cards are important because when 30% of the unit has signed off on those cards, there can be a request for election. I will say that most unions want to get 60 to 70% of the unit have signed off on union authorization cards before they request an election. The idea being some people will fall off, so they like to get that higher percentage. But that's what we're talking about when we're talking about card check organizing, or those authorization cards. So under the PRO Act, if the National Labor Relations Board determines that an employer violated the National Labor Relations Act or otherwise interfered, and I'm not quite sure what that means. To me, that seems like a lower standard than an actual legal violation, right? With a fair election, then there are going to be some penalties. Let's talk a little bit first about what that violation could be, or what interference could be. That could be an overbroad employee handbook policy. We have all seen the swing back and forth between Republican and Democratic administration. I'm sure many of you remember under the Obama board, there were many employee handbooks or rules that were found to be unlawful and a violation of the act. For example, requesting that your employees behave in a civil manner. Well, under Obama, that was found to be a violation, right? So we could see the pendulum swing back on many of those handbook policies, and it can be very hard to track that or know where the line is. There could be an 8A1 violation, like an implied promise that's made by a supervisor during the campaign. Again, it can be very murky where that line is. It's easy to cross that line. Or frankly, maybe a failure to post a notice of an election in a timely manner. That could be found to be an interference. So very low bar for finding that there's some sort of violation. If the NLRB determines that occurred and the employer, you, have not shown that the violation is unlikely to have affected the outcome of the election, then what occurs? The NLRB will set aside the election, but wait, they can then certify the union as the representative for your employees if at any time in the year preceding the election, the majority of employees in the unit sign those authorization cards. So that's a huge change. You know, right now, if there are violations that occur during an election, except in the most truly egregious cases, what happens is the election will be set aside and it'll be rerun. Here, instead of that occurring, the union could just be certified based on saying that they have a majority of cards signed in the unit. You know, there are obviously many things that are concerning about that. One is the fact that it completely undermines a private election, right? You know, we know that people sign union authorization cards for a number of different reasons. They may be feeling pressured. They may be in a situation where someone is watching them. They may not have all the information. They may be misdirected into signing a card. There could be many reasons why an employee signs that card. But really, one of the things that's crucial about our process is that there is an opportunity for a private election. This completely eviscerates that process. It's also going to encourage unions to file charges, right? Why wouldn't you? If I were in the union shoes, I would file charges alleging violations over any little thing that I could. The idea being it's going to give me a second bite at the apple. So this is a huge, huge change. All right, so what if the NLRB orders a new election? I'm sure many of you remember that under Obama, there were changes to the election process and timing there. Many of those changes were rolled back, some under Trump. There was some litigation challenging that. What we would have moving forward under the PRO Act, on the left are a couple changes that would be codified under the PRO Act. On the right are what we have right now. So the pre-election hearing, again, we'd be moving back to kind of what we saw under the Obama administration, 8 days after notice of hearing is served. Right now it's 14 days after notice is served. Notice of petition of election needs to be posted within 2 days under the PRO Act. Notice of petition posted within 5 days currently. And I realize that for those of you who have not been through a campaign, this may not look like such a big difference, but I'll tell you, when you are in the midst of a union campaign and you're trying to figure out the issues, figure out a communication plan, figure out how you are going to get information out there to your employees about the union and about your organization and what might be best for them, every hour, every second really counts. So any shortening of the period of time between a request for election and election is incredibly harmful for the employer. So it may not look like a big deal, but this would be a big change in the process, and it would be in favor of unions and in favor of individuals who are trying to unionize your workforce. And then the last thing I'm going to hit on in my section is just kind of giving you a quick look at some of the damages. Again, this is a big change. If the National Labor Relations Board finds that an employer discriminated against an employee under the Act or committed some kind of violation that resulted in discharge or serious economic harm to the employee, and that could be perhaps an unpaid suspension, that could be maybe a demotion. Lots of different things could kind of fit under that umbrella. The employer, the NLRB shall award back pay without any reduction for interim earnings. So any other wages they've had during that time, unemployment, that doesn't count against back pay. Front pay, consequential damages, so indirect or special damages, and again, not really clear what that could include. It could be quite broad. And then liquidated damages equal to 2 times the amount of damages awarded. Big change, right? Right now, what the NLRB does when they're looking at a situation where someone has been, let's say, terminated because of action that's protected under the National Labor Relations Act, the goal is to get that person back in the position they'd be in without that unlawful action. This is providing additional teeth. It's providing additional damages and really bumping up that damage amount. So again, this is a big change. This really ramps up the stakes when we're looking at potential action under the Act. And with that, I am going to turn it over to my colleague, Jeff. I'd like to say that he'll have some good news for you, but we're going to give you a little bit more practical advice here.
So Kelley, thanks. Really appreciate your presentation and turning this over to me. I have been practicing labor and employment law for 32 years now. So I'm, Kelley said 80 years. I'm 32 years of that. And Bruce Lillie, who you'll hear from here momentarily, is 40 plus years. So we've got a lot of experience in this area. We represent management, right? And so my phone never rings when there's a union organizing campaign going on and say, hey, Jeff, just wanted to let you know this is happening, but don't worry about it. We would love to have the union in our facility. We're just going to go tell them that they're welcome aboard and we'd like to start bargaining with them. So please don't misinterpret where we come from. Our job is to try to help our employers make sure that unions don't come into their facilities, or if they have unions, to help them bargain through the process. So in this slide where we say we hope the PRO Act doesn't pass, or at least gets significantly narrowed, is because our employers don't want us to help them get a union. They want us to help them keep unions away, or if they have them, to make sure that there's a fair process there. At this point, we thought a little dose of reality would help you if you're a non-unionized employer to understand a little more about what happens if you do have a union. And we're going to do that by introducing our good friend from our firm, Bruce Lillie, who is at the Lille Law Firm. He is the founding member of that firm. Bruce and Miller Johnson work together all the time. We work on collective bargaining issues. We have a wonderful relationship with him. And he's going to spend the next 10 minutes essentially talking to you about some of the bargaining process, if in fact you had a union, comparing that to what it's like now when you don't have a union. So Bruce, I'm going to flip this to you and start with your past practice slide.
Great. Thank you very much, Jeff. I really appreciate it. And Kelley and Jeff, thank you very much for inviting me. And hello, everyone. And Jeff's right. I've done this for over 40 years, and I've also been an arbitrator since 1997. So, and all we're really talking about today is past practice. And I really wanted to just focus in on past practice as it relates to the pandemic. But in order to do that, I have to talk just generally about past practice first. So just kind of bear with me here, and we'll get to the past practice aspects as it relates to the pandemic. So the first slide is just basically showing you the US Supreme Court in 1960 said that past practices have essentially the same same effect as collective bargaining agreement language. And so what we really need to do first is to understand what is a past practice. So a past practice pertains to something that's a mandatory subject to bargaining. So if you already have a union, you know that just about everything is a mandatory subject to bargaining. Wages, benefits, hours of work, all kinds of working conditions. And so let's just talk about one of those mandatory subjects of bargaining that are kind of unusual, but we'll use that to kind of show what a past practice is. So believe it or not, whether or not you have a break room and tables and chairs in that break room is a mandatory subject to bargaining. So let's just kind of walk through that and see how a past practice applies to that. So are there tables and chairs in a break room? Unequivocally, as in every day? Yes. Can I articulate that or define that, tables and chairs in a break room? Sure. And are the tables and chairs in a break room for a reasonable period of time so that a reasonable person would expect to see them there tomorrow? Sure. And did you provide the tables and chairs? And did the employees sit in the tables and chairs in the break room? Accepted by both parties? Yes. And so you have a past practice. So, and I could run through 100, probably 1,000 different scenarios with you that show what a past practice is. And we have lots of past practices. And it makes sense that you would have lots of past practices because hopefully you're not bargaining over every possible mandatory subject to bargaining. So past practices are not necessarily bad. It's just that we need to know how to manage them. All right, so there are a number of different ways to manage past practices, and I'm really just going to focus in here on the main ones, the primary ones. And the first one, so let me just kind of go through these, and then we'll move on to the next slide. But there's clear and concise contract language defeats a past practice. Your ability to generate reasonable rules and regulations defeats a past practice, and then the core event changes defeat past practices, and that's really what we're going to focus in on here in a few minutes. And then, of course, you can negotiate past practices away during collective bargaining for a renewal contract. So let's just take a look here at clear and concise contract language. So here at the top, you see time and 1/2 shall be paid for all hours over 8 in a day and over 40 hours in a week. Is that clear contract language? Unfortunately not. And so, because for one thing, what is a day? A day is defined a lot of different ways. Midnight to midnight, 24 hours, 24 hours from the start of shift, lots of different ways of interpreting what a day is. And so what you're really looking for is that language under it, which is time and 1/2 shall be paid for all hours over 8 in a day, midnight to midnight. Over 40 hours in a week beginning on Sunday at 12:01 a.m. That is what clear contract language looks like. So if you're thinking, I've got some contract language that will defeat a past practice, keep in mind that it is clear and concise contract language that will defeat a past practice. And then the next thing that will defeat a past practice is your rule promulgation authority. And that's really just a fancy way of saying that you have the right to generate reasonable rules and regulations. And so this pertains to employee conduct, so you wouldn't be able to change an overtime policy with this or a layoff and recall policy with this. This pertains to employee conduct. Let's say, for example, you have employees that are taking a 10-minute break at the end of their shift to wash up, and you'd like to stop that. Can you do that? Yes, under your ability to generate rules and regulations. You notify the employees, notify the union, promulgate the appropriate rule. And so when it comes to employee conduct, defeating past practices is relatively straightforward. It really is just about promulgating the rule, making sure the employees in the union are notified. So this is the one that we really want to focus on today as it relates to the pandemic. And this is a core event change. And this is something that changes the environment based upon some outside event. So technology changes, manufacturing process changes, product modifications, federal or state laws, customer or client demands, safety concerns, efficiency considerations, and pandemic and act of God. And that's really what we want to talk about here is, okay, during the pandemic, many of my clients have done things that they ordinarily wouldn't do, extended breaks, working from home, ability to change shifts, lots of flexibility for the employees, which is a really good thing because, we're pretty happy that the employees are all coming to work. But at some point in time, we're probably going to go back to some semblance of normalcy. And so the idea is if you've created a past practice where it's because of the pandemic, is it possible to end that past practice simply because the pandemic ends or normalcy returns? Here, and by the way, I don't make up any of these situations. These are all real. So here in this situation, the employer, once the pandemic got underway, they decided to convert some of the administrative offices into additional break rooms, so that employees could socially distance. And then, so instead of a single break area, they ended up with 3 break areas, but they didn't end there. And in those new break areas, they also provided a toaster oven in one of the break areas, and in the other break area, a waffle making machine. And the company provided all the ingredients for the waffles. So this is an ongoing event, as a matter of fact. Since the waffle machine takes several minutes to produce a waffle, and many employees want a waffle, the company has relaxed its break policy and simply allows employees to take as much time as they need to relax and have a waffle. After all, they're coming to work during the pandemic. So do we have a past practice? Have we created a past practice of now having 3 break rooms and a toaster oven and a waffle maker and the waffle ingredients and the extended breaks? We have. And so all of these things are mandatory subjects of bargaining. And so do we meet the criteria for a past practice? Unequivocal, defined, reasonable period of time, mutual or tacit approval. We surely do. And so we have a past practice that was actually created by the pandemic. So we have multiple past practices. So once the pandemic has concluded, or at least normalcy has returned, can the employer discontinue the additional break rooms, toaster oven, waffle maker, and extended breaks? The answer is yes, because the same core event that created that environment, once that core event, the pandemic, is gone, or normalcy returns, then you can return back to where you were before the pandemic. 1 single break room, no toaster oven, no waffle maker, and no extended breaks. And you do that, and so the argument for the employer would be, is that, this was a core event that created the past practice in the first place, and then the core event of the end of the pandemic is what ends the past practices. Now, I've made it sound fairly simple, and it is fairly simple. However, you know what the argument is going to be, and that is, when does the pandemic actually end? When does that next core event actually occur? Does it occur when most of the operation is back to normal? Does it occur when all of the executive orders are gone? Does it occur when the government says so? I don't know. I do know that those will be the arguments going forward. I tried to use a kind of an amusing past practice event here, the waffle machine, the toaster oven, etc. But there are lots of past practices out there that are more interesting and more egregious. But I wanted to use kind of an amusing one just to kind of show you the principles associated with that. So hopefully that helps, and I guess that's more practical than the PRO Act. I'm not sure. The PRO Act seems absolutely amazing and unrealistic, but it is the world today. So Jeff and Kelley and everyone, thank you very much for letting me pitch in.
Not a problem, Bruce. Thanks so much for doing that. And so I appreciate the practical impact, right? And let me try to make that even more clear. If you're a non-unionized employer, all those issues that Bruce just talked about are much easier to handle, because you don't really have to think about my third-party union and how I have to tell them that this needs to stop now. And frankly, as Bruce and I and Kelley know, even if it is a past practice that can be changed because of the court event changing, the union still has the right to grieve it, to file an unfair labor practice charge, to go forward with all of the types of issues that we see often from unionized workforces. So life becomes much more complicated with the union. We wanted to make sure we gave you some practical issues that you can start thinking about to determine whether or not you want a union or don't. Probably most of you understand that difference. Now we have to get back to the PRO Act. Some additional really big changes that we want to make sure we give you before our time is over this morning. So enforcement: if the labor board decides that you've done something wrong based on a charge filed by any employee or a union, and they determine that you've violated that law, now they have the ability to simply make you put a notice posting up for 60 days in your facility, perhaps post it online, perhaps read it to the employees, perhaps send it to them by email. If the PRO Act passes, that changes. Now there's a civil penalty of not more than $10,000 for each violation. So they're putting, the PRO Act is attempting to put teeth into the NLRB's right to enforce their orders. $10,000 is a lot of money for each violation. As you can imagine, with people who are trying to bring a union in, or if a union is there, filing these charges and getting the board to determine that something was done inappropriately is going to create a whole bunch of potential liability for employers that is not under the law currently. So $10,000 for each violation. Next, under the PRO Act, the current law says that the labor board can get an injunction against an employer. This typically happens when the union's trying to come in and the employer decides, for legitimate, objective, non-discriminatory reasons, to terminate the 5 people who are trying to bring the union in. The labor board can go to the federal district court and get an injunction forcing the employer to bring all of those employees back to work and give them back pay. That's discretionary under the board's authority. Now, with this new PRO Act, it's no longer going to be discretionary. If there is a violation under what's called Section 8A1, threats, intimidation, interrogation, promises, spying, or terminations or retaliation, the labor board has to go to federal district court to get an injunction, and the court has to issue the injunction unless, and this is kind of a goofy standard, there is no reasonable likelihood that the NLRB will be successful in the charges that were brought. That's an impossible standard. There's never going to be an instance where the board decides to go to complaint that there's no reasonable likelihood. So there's going to be far more court action involved, which is really a segue into the next part of this, because there is going to be a whole bunch more court action involved under the Labor Act, NLRA, if this PRO Act is passed. Penalties. So we had $10,000 for each violation. Now, if you don't post notices appropriately, or if there's an election, don't get the voter eligibility list out in time, that's a $500 penalty for each violation. And if the union or an employee files an unfair labor practice charge, which is what ULP stands for, the NLRB can make you put a notice posting up and can issue a $50,000 penalty for each violation. And this one's even more difficult. If in the last 5 years an employer has been a repeat offender and terminated someone, that penalty can go up to $100,000. And so those are two very bad things. Let me make it even worse. When the NLRB determines whether or not they're going to issue one of these $50,000 or $100,000 penalties, they get to look at three components. How big of an event it was. So what's the gravity? What's the impact, right? Did the union lose the election? Did employees quit and go somewhere else? And here's the most critical one for privately held organizations. They get to evaluate the employer gross income. Publicly traded company, yeah, that's not such a big deal because you've got to put a lot of your financial data online for people to see. But we work with tons of privately held family businesses who have no interest ever in any way, shape, or form sharing their financial data with anyone. And in this instance, the NLRB is going to get an opportunity to see that financial data, which probably is a pretty big factor related to whether employers who are privately held are going to make some of these decisions if this PRO Act gets passed. Again, I hate to be the bearer of bad news again here this morning, but the PRO Act also provides that individuals at the organizations can be held liable. So civil penalties against officers or directors of the organization in one of three instances: if the officer or director essentially authorized or directed a supervisor or someone else to commit the unfair labor practice charge, or there was a policy or procedure at the employer that allowed that violation to take place, or there was constructive knowledge or actual knowledge that the officer or director had, and that officer or director didn't move forward to try to stop the unfair labor practice. So this is like years worth of litigation over issues that will be individual liability for officers and directors if the PRO Act is passed in its current state. On top of that, not only can you file unfair labor practice charges, but you also have the right as an individual employee to go to federal district court and file an individual lawsuit. Now, there's some weird timing obligations, right? You file your unfair labor practice charge after 60 days and before 150 days, the individual employee can go to court and file a lawsuit. That's a big deal. Employers don't like to be in the middle of litigation. They don't like to spend the amount of money that comes with that litigation, which makes sense. And most unions will understand that that's another leverage technique to get the employer to do what they want, which essentially is to allow the union to come in and to start bargaining collectively with that union. In those civil lawsuits, just like in the other suits that we've talked about with unfair labor practices, back pay, consequential damages, liquidated damages, which is ×2, and punitive damages, going back to those three factors: gravity, impact, employer gross income. And there the court will get to look at the employer gross income. Privately held companies will be very unhappy about that in the process. So one of the issues that's come up in the last several years is that many states, matter of fact, 28 of them now have laws that say you don't have to belong to a union. And when strikes occur, most employees who don't belong to that union don't go on strike. So there's some benefit for the employer to have enough people working to get the product out. The right to work and the right to strike issues would change significantly under the PRO Act. There would no longer be a provision in your contract that can say during a collective bargaining agreement, the union has no right to strike. unions would be entitled to strike during the term of a collective bargaining agreement. As a matter of fact, not only a real strike where everybody walks out and stays out for a long period of time, but intermittent walkouts. We're in one day, we're out the next day, we're in the next day, would be legal, as well as something called secondary boycotts, which is a fancy way of saying unions putting pressure on employer suppliers or employer customers, so picketing at their place of work to convince the current employer to do the right thing with the union. So opening up all of the tools that the union would have to try to force the employer to do what they want. And then I preface this with this last slide, the fair share agreements. Right to work states, there are 28 of them now. Again, employees don't have to belong to the union, but the union has an obligation to represent the employees. That apparently appears to be unfair from the PRO-Act's perspective and from the Democratic administration perspective. So all of those right to work laws essentially would be overturned through the PRO-Act, requiring that any employee working for an employer with a union must pay fees to the union for representation, bargaining, collective bargaining, and enforcement, and all the related expenditures that go with that. Big change. And then finally, and I know we've covered some of this in one of our prior sessions, and we'll cover it in more detail in some of the future sessions, something called the Persuader Rule. So my phone always rings, and Kelley's and Bruce's ring as well, when the union is knocking on an employer's door and the employer is asking us to help them, lawfully put out information to employees to make sure the employees know what their rights are and what a union can and can't do in a place of employment. The unions don't like that very much because they don't like the employees, in our judgment, to have fair information. And so this PRO-Act is going to change what lawyers and what other individuals who help employers can and can't do during one of those organizing campaigns. First and foremost, it's going to prevent the employer from having captive audience speeches where you actually talk to your employees about issues during work time. And secondly, it's going to require people like Bruce, Kelley, and I to sign up as persuaders, to register our firm information, to disclose all of our finances, and to prohibit us from engaging in any help for the employer unless we are registered as a persuader, which is going to have a big bearing on who's willing to engage in that type of activity, all of which is intended to try to make sure that unions have a much better opportunity to get into a workplace because from our perspective, there won't be a balance of information that the employees can consider. So those are the pieces of the PRO-Act that we wanted to get to you this morning. We appreciate the time that you are spending putting into this. I know that this is potentially, 2, 3, 4 months off, but part of why we're doing this is to make sure that you start thinking through where your organization is now and what things you can do proactively currently in anticipation of these changes to make sure that you're in much better shape if the PRO-Act passes to be able to deal with any potential union organizing that goes on. Kelley, Bruce, any final comments before we wrap up?
Nope, I'm good. Thank you very much, Jeff. Except for, the PRO-Act just sounds like just quite a change in the world for sure.
Yeah. No, that was a good summary. Thanks, Jeff.
No problem. We appreciate everybody attending. We don't have any questions listed, so we are going to conclude our presentation at this time. Thank you so much, and we look forward to having you attend some of our future Workplace Wednesdays.